Sure, here is the repeated text as requested. Dimensions of counterterrorism. 1. Legal dimension of counterterrorism. A. Pakistan's context. Nationally, Pakistan has Anti-Terrorism Act 1997, which has been amended several times. There has been some confusion and misuse of the definition of terrorism in Pakistan. In 2019, a larger bench of the Supreme Court was constituted under the Chief Justice of Pakistan, Justice Asif Saeed Khosa, to settle the ambit of terrorism under the law. According to the judgment, the term terrorism can be applied to the use of force under an organized plan for the realization of religious, ideological, or political goals. It can also be applied when, under the plan, terror is struck in the hearts of people and damage dealt to lives and property. The offense of terrorism is also committed when, under an organized plan, religious sectarianism is spread in society. Attacking journalists, the business community, the public, and the social sector under an organized plan also falls within the definition of terrorism. Similarly, an attack on law enforcement agencies and security forces is also terrorism, according to the judgment. Employing an organized plan to cause damage to government property and to commit theft and robbery under such a plan are also acts of terrorism. The judgment also outlined what offenses cannot be viewed as terrorism. The court clearly distinguished in its judgment that acts of violence, such as setting things on fire and extortion, committed under a personal vendetta arising out of enmity or hostility, are not terrorism. Personal enmity as a result of contempt for a person's religion is not terrorism. A person's involvement in an act of violence owing to hostility or personal enmity against the police, army, or government employees does not fall within the scope of terrorism, ruled the court. The Supreme Court clarified that any action constituting an offense, howsoever grave, shocking, brutal, gruesome, or horrifying, does not qualify to be termed as terrorism if it is not committed with the design or purpose specified or mentioned in clauses B or C of subsection 1 of section 6 of the said act. It is further clarified that the actions specified in subsection 2 of section 6 of that act do not qualify to be labeled or characterized as terrorism if such actions are taken in furtherance of personal enmity or private vendetta, said the court in its judgment. It also observed that the definition of terrorism at present, as defined in the Act, is too wide, and the same includes so many actions, designs, and purposes which have no nexus with the generally recognized concept of what terrorism is. In its judgment, the Supreme Court gave an overview of the jurisprudence on the definition of terrorism to show two predominant approaches taken by courts in determining the ambit of the law. One interpretation considered the nature or effect of the act, finding that if the nature of the offense was gruesome, shocking, and created panic amongst society, the act would be considered terrorism even if the motive was private. In one case, for example, the Supreme Court held that the killing of 5 people over a property dispute could be considered terrorism as the killings took place in public and were visible to others living in the neighborhood. Another interpretation considered the purpose, design, or motive behind the act to determine if it constituted terrorism, and found that no matter how heinous or gruesome an offense, it cannot be considered terrorism if the motive behind it is personal vendetta. This approach recognized that the ATA is a harsh law that significantly curtails fair trial rights available to accused under regular criminal law. It therefore sought to ensure that the ATA is applied specifically to cases for which it was originally intended. The larger bench of the Supreme Court agreed with the latter approach and held that terrorism denotes commission of a crime with the design or purpose of destabilizing the government, disturbing the society, or hurting a section of the society. Significantly, the court held creating fear or insecurity in society would in itself not be terrorism, unless the motive itself is to create fear or insecurity in the society, where fear or insecurity is just a byproduct, a fallout, or an unintended consequence of a private crime, it would not be considered terrorism. While the Supreme Court's judgment is an important first step towards limiting the misuse of the ATA, a number of challenges still remain. 1. First, as the court also pointed out in its judgment, the definition of terrorism in the ATA is unnecessarily wide and convoluted. This is because of a series of ill-conceived amendments to the law that have confused and conflated the act, the intention, and the motive that constitute terrorism, making the provision ripe for arbitrary and overbroad application. 2. The ATA also provides that certain offenses contained in the third schedule of the law can exclusively be tried by anti-terrorism courts, and, among others, include kidnapping and abduction for ransom. These offenses do not have to be committed for any specific purpose to be tried under the jurisdiction of ATCs. A large number of offenses tried by ATCs relate to kidnapping and abduction, even where these crimes are motivated by reasons unrelated to terror. It is, therefore, necessary that Parliament reviews the definition of terrorism and the scope of the ATA in line with the Supreme Court judgment, as well as the concluding observations of the UN Human Rights Committee, 2017. In its concluding observations, the Human Rights Committee expressed concern at the very broad definition of terrorism provided for in the Anti-Terrorism Act, as well as the absence of procedural safeguards in court proceedings, and recommended Pakistan should review the ATA with a view to aligning the definition of terrorism in accordance with international standards. Second, all institutions of the state must ensure that the narrow definition of terrorism set out by the Supreme Court is enforced by relevant actors in every tier of the criminal justice system. This includes the police and the prosecution, who include terrorism charges in cases to benefit from the harsh provisions of the ATA or to appease the complainants, as well as courts that have at times expanded the scope of the ATA to cater to populist sentiment.